Record. All right. Hello, everybody. I'm Athrea Mathur. I work as the Director of Legal Research at the Center for Art Law, and I'm really excited to welcome you to Some Like It Digital, Protecting Your Intellectual Property with the Blockchain. Before we introduce our speakers for today, and as per usual, I'll let you know a little bit more about the Center for Art Law and what we do. So we are a Brooklyn-based research and education nonprofit, and we're dedicated to offering resources and programming to advance the arts and law community. Through our website, newsletter, events, we disseminate information, and we try to keep our audience updated on everything art law, whether it's news, cases, programs, movies, podcasts. We also facilitate tons of conversations by hosting and participating in programs such as ours today. And of course, this doesn't even begin to describe everything that we do. So we invite you to take a look at our website and subscribe to our newsletter if you haven't already to receive updates. You may also consider becoming a premium member to receive tons of offers and discounts for our events, access to our case law corner, our articles, and the recordings of all of our past events. We have a good few programs coming up. We have a CLE on digital archives and privacy law. We have a webinar on copyright for artists post the Andy Warhol decision. We have a couple of legal clinics on immigration law and the O1 visa for artists, on artist-dealer relationships, and on legacy and estate planning. And for those of you in New York, we also have a couple of film screenings coming up and one in November. So keep an eye out on our website for more events, dates, and we hope to see you at all of them. A few of the usual housekeeping items for today. The program is being recorded for archival purposes, but as I mentioned, we would love to see more of you. So please feel free to keep your cameras on, but your microphones muted for the moment. And once the recording is available, we will send across a survey to you. And once you complete that survey, you'll get a copy of the handouts and materials for the day, as well as a recording of the session. If you have any questions for our speakers, we will be having a question answer session, so you can put them in the chat box below. And we would invite you to send in your questions. We always really love and appreciate an interactive session. Now I will hand it over to Irina Tarsis, who is our moderator for today's session and also the founder of the Center for Art Law.
Thank you very much, Athrea. I'm delighted to be moderating this panel. Thank you very much to our guests and all of the people in the Zoom room. I'm very curious, and out of curiosity, we'll send a survey to you afterwards, but we are interested in the makeup of the group. So if you wouldn't mind telling us if you're artists or lawyers, or if you're a digital artist or analog artist, let us know who is joining us for this Some Like It digital discussion. As you may know, and if not, I'm happy to report, we have been doing Some Like It digital conversations for a couple of years now, having been inspired by AI that can supposedly authenticate or not artworks. And we learned a lot about blockchain technology and a lot about NFTs. NFTs have kind of peaked, perhaps, have been in the news for different reasons, but blockchain remains a very interesting tool that a lot of people, including artists, are focusing their attention and time on. We are not necessarily, well, I don't know how many of you are NFT collectors or digital artists. It remains to be seen, but you may be curious about what AI is doing vis-a-vis intellectual property, vis-a-vis visual arts. There are issues with AI may be or maybe not meriting copyright. As you may know, Copyright Office is seeking comments from all members of the community, from lawyers to non-lawyers interested in this subject. The center is planning to submit its comments together with many, many other organizations, law firms. And we are curious about your position on AI. We will ask our speakers about it as well. Very recently, Athrea sat down and had a wonderful interview with our guest, Andy Rosen. I invite you to read the interview if you haven't yet. It has fantastic materials. It's very nice to see artists dealing with not only artistic endeavors, but also technology. We don't venture into the space too much, but we love hearing about it. And I would like to invite you also to think about the conversations that have been recorded in the past. If you have questions, we will be happy to put you in touch with both our speakers from former events, and we invite you to give suggestions for speakers in the future. So we're talking about copyright licensing, maybe AI, definitely blockchain, and really we're talking about arts. So our first, and I feel strongly our main speaker guest is Andy Rosen. He's a photographer. I wish I were a photographer, but I didn't have the belief that my eye was as valuable or as interesting. Andy has been a photographer for a few decades. He started in analog space and he moved into digital. And Andy, welcome to the center. Welcome back. Thank you for the interview, and thank you for agreeing to talk to us about your work and your inspiration. And we'll talk about your entrepreneurial work towards the end of the presentation, but we would love to hear from you about how you got there to here.
Well, interestingly, I started off in the analog world, as you just said, and kind of ended up in the digital world. So I've kind of seen it from this transition, which is still going on and probably will be going on for the next decade. And I've kind of had three phases. One, I was a photographer. I mean, I still am, but I'm more of a software developer now. But the three phases were, from photography to the video age, and then to obviously software development. I've always been more interested in moving forward than sort of looking back. And I started, basically, when I started photography, it really wasn't like it is today. I walked into, I was a schoolboy photographer. My father was an amateur photographer, so I sort of spent a lot of time with him in the darkroom. And really, when I left school, punk kind of started. And really, as I say to people, I think that there's a lot of luck and timing is really important. And you're lucky if you catch it. I've just been really very lucky. I think the year I was born, I've just synchronized with three major kind of changes in, modern culture. So I walked in innocently. I left school, punk started. I walked into Record Mirror, which was a national newspaper, music, paper. There was only four. And just innocently with a schoolboy portfolio, just sort of school plays, girlfriends maybe, and sort of adventures with my friends, really, nothing really that focused. And I don't think there was a lot of people competing for the job. Now, obviously, everybody's a writer, photographer. Back then, or, everybody's everything, because the accessibility now to the tools is incredible. So, especially with AI now. But getting back to photography, I walked in and Alf Martin, who you won't know, but was last of the old school editors, looked at my portfolio and gave me an assignment right there and then. And I really was just astounded. I really didn't really know what it meant to be a professional photographer or a music photographer. But I just sort of put one foot in front of the other. And within a month, I became staff photographer. And then really for the next sort of decade, I floated between all of the magazines. Back then, there was only four. I'm just looking at some notes. There was Record Mirror, which I was staff photographer for. Then I moved on to Sounds. I freelanced at NME, a Melody Maker. And back then, you've got to remember that most of it was black and white. There was no color. The only color was either the cover or the center pages. So a lot of my work was sort of black and white, mainly because there wasn't a lot of color work commissioned. And really from there, I had incredible access. And again, the luck was that when I left school and became a photographer, I sort of collided with the punk scene, which was an incredible moment, as it turned out. Not that I realized at the time. If I had, I probably would have taken more photos. But it was an incredible experience to be a photographer starting out and to have such incredible subjects. I mean, every band that I photographed. I'm going to switch actually and share my screen, which I think would be interesting. Hold on. Can you see that? Or is that?
Yes, it's coming up.
Okay. So, yeah, I was just incredibly lucky in a way. I think that luck plays a big part. I'm big on this. I'm not saying that you don't need talent. I'm not saying that you don't have to have like a lot of endurance to do anything creative, because it's a hard working life in a way. You have lots of ups and downs. But I think timing is everything, and that's luck. I mean, if I wasn't born, I think, and left school at the time that I did, I don't think I would have hit the music scene, or at least the punk scene, as I did. And also photography was in a bit of a lull. As I said, I don't think a lot of people were competing for my job. Nowadays, everybody's wanting to be a photographer and be a music photographer. And in a way, there's a lot of photography that's not even commissioned. Friends of the band have iPhones. So it's a whole different world. But back then, they needed staff photography, and it was quite a sort of chemical process. Remember, I was dealing with film and darkrooms and things like that. So it wasn't instant. So, it was a little bit of a different world. And really, I kind of, I left England, ended up in Australia. And again, luck played a big part. I ended up in Australia in 1985, I think, which was the biggest year of Australian rock. There was In Excess, Midnight Oil, Crowded House. I don't know if anyone remembers those bands, but it was an incredible moment in Australian rock. And I fell right into that scene and ended up working with all these bands. And then from there, just to cut a long story short, I ended up in New York, which I loved, but I was looking for something different. Ended up in Los Angeles, which I liked living there. But the photography I wasn't really into the photography there for a number of reasons. There was only the film industry, really, and then heavy metal bands. And coming from the punk scene where every band was different, heavy metal bands, not that I don't have anything against heavy metal bands, but really they all looked the same, long hair, spandex trousers. It just wasn't exciting for me. So my agent got me into doing movie stills, which was great. I'm always interested in sort of learning something new or moving forward. And I did like 8 movies back to back. And that was kind of interesting, watching how they made a movie or make movies. And my job was really to sit on set and just photograph everything that moved for the publicity. Usually it was the car chases and the big action things. And back then, when you went to the cinema, there used to be big photographs, outside showing the movie. They don't really have that now, as everything's moved to the internet. So it's a little bit different. And I did that, as I said, for eight movies. And it got a bit repetitive. You're just sitting there, getting up, taking a picture, sitting down. But what I did learn was how they were producing a movie. And then again, complete luck and timing, I think, that the MTV and the video world was beginning. And obviously it's kind of like now, these old film directors and people that love film were very anti-video. Nobody saw MTV coming. And I came off 8 movies. I had a bit of money and I just went for it. I started like a production company, which seemed like about the only other thing I could do, because I didn't want to do, heavy metal bands. I liked living in LA. It was just so different than London and New York. And I started a company called The Underground, and just hit the beginning of the transition from film, analog film, to sort of video. And from there, we shot everybody. I'm just looking at my notes because let me just see. I did everything from Ozzy Osbourne, Metallica, Van Halen, Marilyn Manson, Shania Twain, Bowie, Dave Matthews, Puff Daddy, 9 Inch Nails, and again had like a decade. It seems like all of my creative pursuits always last a decade. Okay, and then I sort of move on, or it just coincides with something new coming up and I get involved in that. So I kind of worked with masses of bands, but about 2000, I realized I saw what was happening, that the accessibility to technology and access to sort of equipment was sort of, and the competition was now, everybody had access to the tools. I'll give you an idea. We used to shoot animation commercials that would take probably 3 or 4 months to shoot 30 seconds. And there was now people that were coming in and showing me work they were doing on a laptop with $200 worth of software, that they could do what we were doing, not the same quality. I mean, film and, big production does have a quality edge, but I think it's irrelevant now because most content is on the internet. You don't need a 35mm camera or big video stuff and equipment, if you think about it. Back then you did. So I kind of saw the writing on the wall. Even though we were doing really well, the underground also hit. Again, it sounds as though it's kind of crazy, but it's true. I hit the whole .com era. So we started off as a sort of video production company. Then the dot-com era started. So we moved into digital agency, web design. We put Motown online. And it was way back, just like, Netscape, if anyone remembers that. That was the big browser before any of the other browsers. And from there, it's sort of, I realized that the party was over with the sort of video production company. And I started to retool into a digital producer. So I started to learn software development, and I started building applications to solve the problem back then, which was, how do you share valuable content? How do you sort of, protect it? And it was very early days of all that. Web applications were just starting. So that was a new thing where everything moved to the web. And I kind of went from there to where I am now, which is a company that I've started called File Protected, which is very much a continuation of what I've always been involved in, which is independent talent, protecting it, and helping them sort of monetize their work and sort of manage sort of careers. And now I think it's come down to a point where there's no room for the fat anymore. And the fat was sort of middlemen, agents, managers. There's just not enough money. And I think that it's quite complex navigating for a lot of creative people, this sort of digital world. Not only is it difficult in some ways, but it's changing all the time. So File Protected, and my emphasis is really continuing what I started doing, I suppose, when I started the underground, which was very much doing that in the sort of beginning of the sort of transition from analog to digital. So I don't know if that sort of makes sense. I'm kind of condensed a lot into a short space.
That sounds great. Thank you. I have a couple of follow-up questions, and we have a brief video that we may play in parts to explain what File Protected is. But Andy, a couple of questions. Being on the scene and taking a lot of these photographs and seeing them reproduced in magazines and then online and so on, did you think about your copyright in these works?
It's really, no, look, when I first started, I really didn't think about it at all. I was just so excited to be a photographer. I had no concept of the business side of it. I was just sort of really just excited. I was young. It was also like a mini 60s where, the punk bands didn't want to work with the old school. So they embraced young photographers like me. And I didn't really think. I was just, as I said, just excited to work and be photographing bands. The first time, and back then there wasn't, copyright was not something that I'd even spoke to other photographers about until one day I got an assignment to photograph Duran Duran at the top of their career. And basically I took the picture and it was worth a lot of money. And that was the first time that I realized that images could be worth a lot more money than I was getting paid just to work for the magazine or the newspaper. And all of the parties, there was...
Hold on, sorry to interrupt you. So it was not the first thought on your mind when you were
not at all
making them. And do you remember if it's a tricky loaded question. At what point do you remember starting to work with attorneys on your various projects?
Well, basically, as music became sort of much more popular as a medium, okay, and there was more newspapers and magazines, and it really took off. There was just a huge amount of magazines started, and the worth of photography suddenly became a lot more. And what happened was the first taste of copyright was that management realized that I was starting to syndicate images and there was merchandising and all this was starting to take off. So they had this thing, which I don't know if it was legal, but I think it was at the time. And remember, this was 1976, 77, 78, which was early days for copyright, which kind of changes a lot in terms of all of the conventions. And what they used to do was they would buy the film. I'd come to the session. They'd give me the film that I'd tell them that I wanted. And then when I finished the session, they'd actually take the film back. So it was a horrible experience. So I never got to actually process it anymore or do what I wanted to do. And that was the first beat. And all the photographers that I knew kind of hated that whole thing. So what happened with Duran Duran was I got into like a session to photograph them. And the people from the record company were so in awe of the band, they forgot to give me the film or anything. So I knew what was happening, to be honest with you. And I shot the band and they left. And I remember just jumping up and saying, wow, I beat them at their own game kind of thing. And I knew this picture was worth a lot of money, which it was. That was the first time I actually made real money. I mean, I bought a car from it, and that was back in 1977. So that shows you how photography was starting to make a lot of money outside of just the assignment. And I got attacked by everybody, and everybody from the record company, from the magazine I was working with. Now, the magazine I was working with never paid me, but I was allowed to keep the copyright. But suddenly, and the management, so it was the management, the magazine, and everybody, they were wrong, but they tried to sort of intimidate me. And that was the first time that I ever got an attorney. And it cost me an arm and a leg, but I had the money to pay for it. And I beat them very, very quickly. I mean, there was no dispute legally that I own the copyright. They didn't buy the film. They didn't make me sign a contract. So that was my first taste. And I suppose in a way that never left me in a way, because
I have to interrupt you again. Sorry. Okay. I have to interrupt you again. So we have, fortunately, Athrea, thank you for sharing. There's a link to the interview with an image in it. So for those of you who would like to take a look, it's there. I would like to quickly show a couple of scenes, I suppose, from File Protect. It is, it's a 4-minute informational file. Again, we'll put it in the chat for those of you artists interested or creators interested in controlling, I suppose, your stock more. And we'll then switch and hear from our attorney guest about some of the concepts that Andy mentioned. And I invite all of you to put in questions and comments into chat while we are looking at this.
Power to independently protect, control, and monetize your content directly and receive the credit and compensation you deserve. File-protected use of the blockchain is one part of an integrated feature set built to meet the demands of a new generation of content creators. With File Protected, not only can creators safeguard their work, but they can also easily share, transact, deliver, and monetize it wherever it travels. At the heart of File Protected is the Creative ID system. This unique identifier is more than just a registration. It's a passport for creative work, providing an always-on direct link to the creator, their work, proof of ownership, and sales. The Creative ID also promotes trust and transparency by enabling viewers to independently verify the ownership, authenticity, and the integrity of the content being viewed or sold.
So one of the features, as I understand, of this software or application that is File Protected, it's to allow some of the content that has never been published to be shared without any concern that, well, without strong concerns that materials might be misused. Is that right? Can you say a couple of words about this idea of?
I think it's more about attribution, and there's no dispute using the blockchain that who owns it. And I think that, you know, File Protected isn't copyright per se. In fact, we actually support copyright by providing some of the sort of weaknesses as we move forward with copyright. But I think as we enter the digital world, what's more important is authentication, attribution, and monetization. And I actually believe that infringement can be quite positive. And what I mean by that is that most infringement that happens with my work every day is usually fans, mum and pop shops, you know, it's not big magazines and stuff. So I've noticed that my sales have increased incredibly because they're working as my agent kind of thing. So I actually say to people that within reason, having your work infringed, it really depends who it is, but being scared of letting it out over the internet, I think as we move forward, and I advise a lot of, you know, creative people still, that they shouldn't be scared of their work being published by other people as long as they're not abusing it. And if they are, then copyright can you know, solve that or try and solve that problem. That makes sense.
Thank
so
you.
File Protect, yeah, go on.
Thank you. Again, if there are questions, please put them in chat. We're gonna switch hats and we will look at the same concepts through the lens of an attorney now. And one of the lawsuits that has been decided, maybe it might be appealed, but there's an interesting decision from the District of Columbia in connection with copyright, whether an artificial intelligence can own copyright or not. And the reason I'm using this image to introduce our next speaker, Scott Sholder, is a litigator, but not only, an expert on intellectual property, copyright, and many other subjects. And as our expert on copyright law of today and licensing, on protections that are available to artists, I am very happy to welcome Scott, and we invite him to comment on these big topics.
Thanks. Thank you for having me. So I think I'm not entirely sure how well versed the participants in this webinar are on the basics of copyright law. So I'll give a very short presentation on kind of the basics of copyright protection, what it covers, what it doesn't cover, and then we can kind of get into more questions once the foundation is laid down. So let me share. Are we seeing the correct slides? Good. Okay. All right. So copyright protection at its heart stems from the United States Constitution, Article 1, Section 8, Clause 8. This is obviously very antiquated language, but the Constitution gives Congress the power to promote progress of science and the useful arts by securing for a limited time to authors and inventors the exclusive rights to their respective writings and discoveries. So again, old-timey language. Science and writings actually refers to copyrightable materials, and useful arts, this refers to science and patents. So it's a little bit backwards, but essentially Congress can pass legislation protecting intellectual property for limited times. And they have done that several times. The first Copyright Act was passed in 1790. There was a 1909 Act in kind of in the middle there. The most recent one is the Copyright Act of 1976, which went into effect on January 1st, 1978. So we're still a little bit behind the times. There have been a couple of amendments, including the 1989 adherence, for the most part, to the Berne Convention, which did away with a lot of the kind of very technical formalities you needed to satisfy in order to secure a copyright, and then the Digital Millennium Copyright Act in 1998. Those are kind of the biggest amendments, in recent years. I'm not going to go into things like the Music Modernization Act or anything like that, but just for very basic purposes here. So there tends to be a lot of confusion between copyright and trademark and copyright and patents, and what copyright covers and doesn't cover. So Section 102 of the 1976 Act states that copyright protection subsists in original works of authorship fixed in a tangible medium of expression, including the following list. So fixation is important. It gets trickier as technology advances. So when you're talking about things that are computerized, that are stored in computer memory, there can be arguments about fixation. What is sufficiently fixed? Basically anything that's saved on a computer in a file that's retrievable is going to be deemed fixed. Photograph is fixed as soon as it's taken. A digital photograph is fixed as soon as it's taken. It's saved on some sort of computer hard drive. Fixation issues can come into play when the technology gets a little bit more complicated. But for our purposes, it's fairly straightforward. And so you've got a list here of 8 categories of works that are protected by copyright law: literary, musical, dramatic work, sound recordings, which came later, architectural works. For our purposes, pictorial, graphic, and sculptural works include all things like photography, paintings, sculptures, etc. And then motion pictures and audiovisual works, obviously movies, television, things like that. So we're not talking about brand names and short phrases and marks and things like that. Brings us to works copyright does not cover. Ideas and facts not covered by copyright. If you put them together in an original way, You can get protection over the selection, arrangement, and coordination of those unprotectable individual elements, but it's a different level of protection. Generally, it's a bit weaker, and in order to show infringement, you have to show that there was exact copying. This is why a lot of people with kind of idea theft cases have a difficult time in asserting copyright claims. That they say, you know, this TV studio or movie studio took my idea for a reality show or for a sitcom. The idea is not protectable. The concept, the format, things like that. You have to show that actual expression was taken. It's the expression of the idea, the unique expression to the individual originality is what's protected by copyright law. Words, titles, and short phrases, that's really the province of trademark law. Unfixed works like choreography can be protected if it's written down, but you know, kind of ephemeral things that come and go and are not fixed aren't going to be deemed protected. Things like useful articles covered by patent law. Functionality is not covered by copyright. And when we get into, if we get into the AI space at all, works by non-humans have been pretty generally deemed uncopyrightable to the extent that they have not been touched by some sort of human, given some human contributions. Moral rights you hear a lot about in the context of European copyright law and European, Canadian, almost all the other countries except for us, that deals with attribution and defacing of property and you know, alteration of work such that the author no longer wants to be associated with it. We have a very narrow form of that called the Visual Artist Rights Act, but we generally don't recognize moral rights, for better or for worse. The rights that are granted when you have a copyright in something are generally considered a bundle. So when you create a work, it's copyrighted upon creation, and you automatically have the right of reproduction, preparation of derivative works, distribution, public performance, public display, and public performance of certain digital audio recordings. These are the rights that belong exclusively to the copyright owner. They can be individually licensed or assigned, and if somebody else does something that falls within one of these 6 rights, that can be deemed an infringement depending on the circumstances. So talking about ownership of copyright, I mentioned that as soon as you fix a work in a tangible medium of expression, it is considered yours and copyrighted. We'll get into registration later. It's a little bit counterintuitive that you can't actually sue for infringement unless you have a registration, not an application to the Copyright Office to register the work, an actual application in hand. Those are the keys to the courthouse. Again, it's counterintuitive because theoretically you own the copyright as soon as you fix the work, but you can't do anything about it if somebody infringes it unless you register it. So there are a few different types of ownership once the work is fixed and kind of in your ownership as the author. There are sole authors, joint authors, which requires certain elements to be satisfied, intent and some copyrightable contribution. When you have joint authorship, generally it's 50-50 unless there's an agreement otherwise, and each author can exploit the work, including making non-exclusive licenses as long as they account to the other owner. Works made for hire, tricky area. Those are works created within the scope of an employment for an employer or specially commissioned works pursuant to a written contract. For works that were created before the 1976 Act, there's a different test. It's called the instance and expense test. So it's similar to trying to figure out if somebody was an employee, but basically if the hiring party provided all the means and motivations for creating the work, then they might be deemed the owner or author at the outset. Copyrights can be assigned by a written agreement, and they are descendable by will or intestate succession. So I mentioned briefly about registration. Copyright works are protected once they're fixed, but registration is required to enforce. So licensing something is of less value if the work is not registered because there's not an ability to enforce it. Registration is fairly simple. It's inexpensive. It's less than $50 for a single work if you do it online. You can do it by mail. Generally, the turnaround is fairly high, several months. It takes several months for the Copyright Office to get through an application. You can expedite it for about $800 if you really need to. One circumstance is if you're, imminently filing a lawsuit, you may want to do that. But it is recommended as a best practice to register your works. Allows you to enforce them, and it allows you to, in some circumstances, if you've done it in a timely manner, get statutory damages and attorney's fees if you win. A little bit more on registration. As I mentioned before, application does not equate to registration. You need to actually wait for a determination to be made on your application, and the Copyright Office can deny it if they determine that it's not original enough, or there are some other problems with the application. We talked about infringement already. You have to send deposit copies to the Library of Congress. All of these things depends on the type of work that you're registering and how you're registering it. There are detailed instructions on the Copyright Office website and forms. It's important to note that the deposit copy has to be the exact work that you're applying to register. And registration with the U.S. Copyright Office for purposes of securing your right to sue and pursue certain damages is very different from registering a work with other organizations like the Writers Guild, BMI or ASCAP for musical works, and services like Andy's File Protected. These are very different forms of registration. There are certainly benefits to registering with all relevant organizations, but registering with the Copyright Office is what gives you the enforceable registration, as opposed to some of these other organizations. And to talk about enforceability, like what do I mean by that? I mean suing somebody for copyright infringement. So someone who violates one of the exclusive rights that I mentioned below, and for visual works like we're talking about today, that's usually going to be reproduction, distribution, or public display. So somebody who violates those exclusive rights and does one of those things without permission is going to be an infringer. They have to have copied protected material, and again, not just ideas or facts, and the use has to be substantially similar. So if somebody takes one of Andy's photos in full and does something with it that they're not supposed to, tries to sell it or make prints or make t-shirts, they've copied the whole thing and they're doing something that only Andy has the right to do. If they, obviously there are exceptions to the rule. There's fair use, which is very gray. There's de minimis copying, which is copying so little that it's not deemed infringement. So that all those things will factor into whether there has been an actionable copying. And substantial similarity will come in when somebody, makes something that is, they try to copy Andy's work by taking a very similar photograph. If the expression is similar, or in the context of a painting, if somebody tries to recreate somebody else's painting and makes it very similar, that's potentially infringing. So it doesn't have to be an exact duplication of a work. Substantial similarity really is the test that is used to determine whether an infringement has taken place. And again, there are ways to procure images in a way that does not infringe anyone's copyright. Many photographers use stock content agencies. They enter into agreements with companies like Getty Images, Shutterstock, Adobe, Alamy. There's a lot of these players out there, who host databases full of excellent content that users can subscribe and pay license fees to use, and so that the creators are compensated. And there are certain reps and warranties and indemnities that go along with having a subscription to some of these services. Again, submitting content to one of these organizations for licensing, not the same as registration and not the same as having a copyright. So generally, before submitting content to services like these, you'll want to get a copyright registration. And for photographers, there are ways to do that in bundles. You can register many works at once, just depending on the type of work, so that you don't have to spend money every time you submit one photograph. The other ways to procure content potentially with lower risk is, figuring out what's in the public domain. If the copyright has expired, there are various ways of figuring that out. And then Creative Commons licenses, you may need to credit the creator or agree not to use the work in a commercial way. There are various different types of Creative Commons licenses. The only thing to note is that there is still some risk in the sense that this Creative Commons content is not necessarily vetted, and I'm not aware of any indemnities that go along with it. So somebody could submit something in theory that's not theirs, and say it's available in Creative Commons, and so there still is a little bit of risk. So you need to do a little bit of diligence when using things that are supposedly in the public domain or free to use. There are other copyright other content websites that allow for free or low cost images that they can guarantee or at least will indemnify for any problems that come later. But again, different issues from registration, but registration, protection, enforcement, and the kind of clean, for lack of a better term, procurement of content in a licensed way that doesn't infringe others' rights is important, and they're all kind of a piece of the same discussion. And that brings me to, why not just pull content from the internet? There's a misconception among some folks out there that if it's on Google Images, it must be for free, and I can just right-click save and do whatever I want with it. That's not true. You can't do that. There's generally no license for doing that. You're not indemnified. That the images haven't been cleared, and just generally it's copyright infringement. If something is on the internet, you take it without permission or without a license, it's infringing. Just because something is on the internet doesn't mean it's free to use. Penalties can be high, and there's a cottage industry of suing for image use online. So beware when using services like Google Images or just pulling things off of social media, because that's a hotbed for litigation. And that's all I've got for my slides. So I'll turn it back over to my friends at the Center for Art Law and see where they want to go next.
Thank you, Scott. Thank you for doing a quick tutorial to the 15 chapters of the Copyright Act. You did not mention the small claims board that was created last year to address some of these issues where artists may not have the necessary funds or time to go through a protracted litigation to protect their copyright. And one of the elements of your work, Andy, as I understand, is to give creators, artists, more tools to decide how to deal with their intellectual property without necessarily turning to the Copyright Office for the protections that it promises, but not necessarily always is able to provide. We have a few questions in the chat, so I will ask you, Scott, if somebody commissions a visual art photo shoot, for example, who owns the works today? If is it a work for hire or is it not a work for hire? I think from 2023 position, how would you advise an artist who is asked, and how would you advise a sitter, I suppose?
Yeah, so the work for hire is a defined term in the Copyright Act, so it's pretty clearly laid out as to what falls within that category. If you're not an employee of the person or company that's commissioning the work, then it has to be done pursuant to a written agreement and as part of a specially commissioned project, falling under certain categories. I don't have the statute in front of me, but I don't recall just a painting or photo shoot being one of the listed categories in the statute. So it would have to be like a lot of contracts will just say it's a work for hire, even if it's not. And they'll say, well, to the extent this is not a work for hire, it's you assign me all the rights. It's the assignment that gets you the rights in that circumstance. So if there is a written contract that says you're assigning all the rights to whoever is commissioning it, then the commissioning party would potentially be the owner. But it's really going to depend on the circumstances and the type of work that's being created. I don't recall that a kind of single painting or photograph falls within the statutory definition. So I would think you would need a written assignment for somebody else to be the author.
Andy, the way, so you moved from being the photographer to, I'm paraphrasing, and you can disagree with me, to advising and maybe working with other photographers and content creators, to perhaps enabling photographers and content creators, visual content creators, to manage their intellectual property. So let's say there is a photographer. I know that File Protected is in beta, so you have a few people using and testing it. But would you recommend photographers who do, for example, something like a photo shoot, posting all images there, sharing them with their client, and then client decides what they license? Or is that just too overkill, too much content, and it does not make sense to have all of that on blockchain?
No, look, I think even if you're a photographer and you use copyright off this, you're not going to register all of your content. I think when you go through a shoot, you're going to choose the selects. You can certainly do that. And with the blockchain, you can actually register everything if you want. But I think that, what am I trying to say here? I think that it makes, I think what we do, when I say that we support copyright, and you brought up the lower copyright courts, basically. What was it called?
It's called Small Claims Board, yes.
I think where we help and support copyright is that it comes down to, getting the judge or the court enough information quickly, right? So when you register something with us, you can actually prove, quite honestly, that you were first, or you own the content, or collect whatever, events around that, because File Protected doesn't just focus on the asset, it focuses on the context and the events. And often the context and the events, and Scott could probably say this, are sort of very relative in a copyright case, like what was said, what was arranged, and sometimes it gets very murky. So I think what we do is provide accurate information, okay, that can be submitted to a court. Obviously, it's moving through the court system. It's obviously blockchain's new, and you'd probably need a legal expert to sort of determine if this evidence is relative, but that goes for any evidence, I would imagine. So I think, as I said, there's also other uses. Remember that we're focused on copyright, to me, is a sort of more of an analog tool in a way. And as we move forward, there's other use cases for proving you own something. There's like takedown notices that really don't have much to do with copyright in my mind. So that, and you can use a registration. What you have to do is send, the host, basically, or the hosting party, evidence that it is your content and you want it removed. Okay, so I've already used File Protected to do that, and it works. You don't need an attorney to do that. So I foresee moving forward that there's lots of other uses. It's not just copyright. It's authentication and attribution, which is what's lost. So in terms of infringement, the worst thing about infringement is if you don't get a credit. So nobody knows that it's your work, right? So nobody can get back to you. Nobody can contact you. And that's really the worst thing to me about most, copyright infringement. As I said, if someone uses it to merchandise something, that's a problem, or if they use it to monetize it. But a lot of infringement isn't that, I think. And a lot of cases are actually quite small, are under 30,000, which is, I think, why there's this new court system, which I think is really good. It's just the first stages. It's not, it's not mandatory. So both parties, as I understand it, have to agree to commit to, a case. So that leaves a little bit of a problem, that if it's not mandatory, then you really don't have to go if you don't want to. So, but I think it's going to evolve because I think the market needs that, especially with AI and all the sort of new emerging mediums that is having problems being recognized by the Copyright Office. I think that there's a sort of a real use case, as I said, outside of traditional copyright, of identifying content and who owns it, and if it's yours and if it's authentic.
It's very interesting. In our preparatory calls, we discussed lots of different variations of this program, but it just occurred to me, if you remember, there was a case where Haiti photographs were published without the correct attribution to the photographer, because there was an element of urgency and a wrong name was attached to the images. So theoretically, if photographers post everything on File Protected or some other platform with information, then that content is not married but indivisible. Do you think that would solve some of the problems of there's an urgency?
I think Scott would sort of, maybe chime in here, that I think the more information, the more context you can bring to a case, it's got to be relative. And I think, blockchain isn't so new anymore, but it is moving through the courts. And even the Copyright Office, as I understand it, is looking for some sort of blockchain system. Might not be the blockchain as I'm using it, might be their own blockchain. But there's definitely a use case for having a sort of accurate documentation of something that's cheap and simple. Because remember, there's so much content now. If you think of Instagram, there's 100 million images or more and videos on Instagram, added to Instagram every day. That's just Instagram. So when, copyright was first came about, I think it was the British that introduced it in, well, Scott will know, in 1790 or something. There was the sort of printing press, and the horse and cart was sort of distribution. So in my way, I think copyright is really important. I just think it needs to evolve to sort of complement the digital era. And I think we're already seeing the sort of cracks really with AI and these new emerging mediums, which are no different than when photography was introduced. If you look at the history, we went through the same thing. Everyone said photography back in the 1880 or 70 or whatever, that it was mechanical, you can't copyright it. But there actually was a case, I was just researching this recently, where I think it was Oscar Wilde was actually photographed by someone. I think you might have seen the press recently about it. But, that's a really interesting article, because it really, in my mind, shows where AI is going to end up. At some point, there's going to be a lot of legalities and lawsuits and stuff. And I've got lots of opinions on that. But I think that eventually AI is art, and people that use AI is no different than photography. I know a lot of people are going to sort of probably have a different opinion, but I really do believe within a decade at least, we're going to get over this period. And AI will just be like photography. It will just be recognized as an art form. And some of the stuff that I've seen, and I'm very into it on a personal level, is incredible. I mean, it's just incredible to have this new tool that you can create. And I think the best thing about it is it gives everybody the chance to sort of express themselves creatively. And I think, all artists get something from it, but it's been a sort of proprietary world. You've got to, especially commercial artists. I mean, remember that we're talking really, when we talk copyright, about commercial artists. And there's a difference between commercial art and sort of art that people do because they wake up in the morning and they want to create whatever it is, a collage or anything. Does that make sense? I just think that,
Sure. Hold on.
something.
I'm going to interject, Andy. Hold on a second. Scott, I wanted to ask you, what value, evidentiary value, do you anticipate blockchain offering to copyright claims?
Well, to Andy's point, the law has lags behind technology a lot. So at some point, I'm hopeful that courts will start to catch up and be more comfortable embracing new technologies. I think blockchain has significant potential for, evidentiary value, where something is immutable and can't be changed. I guess the problem is that it's the garbage in, garbage out problem. I can put an entry on the blockchain saying that I own one of Andy's photographs, and that's completely false. And that can't be changed. It can be amended by a subsequent block on the chain, but so it kind of goes both ways. It can be seen as very as potentially very trustworthy, but there are also problems with it. So just like any technology, it's a bit of a mixed bag. So courts have to get used to evidence being preserved and presented in this way, and some courts will probably be open to it and some won't. I think it has significant potential for a great use case in litigation, in copyright litigation. When somebody has a immutable record of creation, showing proof of independent creation is an excellent defense to a claim of infringement. Somebody says that, hey, you copied my work, and you have a clear record registered on the blockchain of showing, no, actually, I created this work before you even came along and licensed it and made money off of it and whatever. That's potentially really helpful in a lot of circumstances, not just in the visual arts. So I think there's great potential for it. I don't think it's certainly not regular practice now, but I hope that it does become that way.
Hey, can I ask another question? Actually, that just come into my head. If you were in a lawsuit and a big lawsuit about copyright, and I sent you, and it was over one of my images, okay, and I'm trying to prove to you that I own it. If I sent you a blockchain registration, that even though it's not recognized by the courts, but you understand the blockchain and you could see that I did have sort of proof, you might, as an attorney, say, well, I've seen the sort of proof, even though it's not enforceable through the courts. It might, stop a lawsuit because you kind of know that I've got proof. Does that make sense? That it's almost like if I showed you that it was mine, I could show you that I registered it first. And there's other things happening. Google's now getting involved where we'll be able to use the context of when my image was first on the net, and we can prove that. I mean, what would your response be to your client? Would you advise them to keep going, or you would have a little bit of a sort of beat that maybe there is some truth here and the lawsuit might not end up the way that you want it to end up? Does that make sense?
Yeah, no, I totally understand what you're saying. I think it certainly has the potential to push early resolutions. A lot of times you get into a dispute where somebody on the other side, very forcefully disputes independent creation and says, no, I created this and this is my original thing and I came first. And if there is a providing evidence to show otherwise really can help resolve a case before it goes too far, even before it goes to litigation. So having a digital record like that, I think, is really valuable in avoiding litigation. So yeah, I think it obviously depends on the circumstances, but I think providing that kind of evidence early on really could help resolve cases before they get too far.
Yeah, no,
Thank
it's just interesting. Yeah.
Thank you both. If we have more questions from the audience, please put them in the chat. And also, we are available to answer questions after the program is over. Materials that have been recorded and put together as reading materials will be shared with you after the event. Andy, I'm wondering when you will start opening the file protected to more users.
Very, very soon. I mean, as I said, the most important part, releasing an application is actually quite easy. You just release it. But what's more important is that I'm working with a diverse group of people. So it's not just photographers, it's any creative person. If you create anything, it's writers, just anything that you want to authenticate and, make sure that you can stamp it with your attribution. And again, file protected is very much focused, obviously registration and all that, but very much focused on helping people monetize their work. And in the sort of meetings I'm having with young and older artists, that's really a focus at the moment. They're not talking about copyright, in my opinion. Do you know what I mean by that? They're more focused on how are we going to survive with AI and all these things. So offering the kind of tools that we do, we also have a marketplace, as you know, where we don't charge for any of the licensing. We just allow the clients and the photographer to sort of meet and do their own transaction, and we don't take any percentage. And that's an example of really where I come from, which is, trying to help and support independent artists, really, even though file protected can be used by anybody. not just for, independent artists. So I suppose the emphasis is, I believe, moving forward, is how artists are going to survive, how they're going to get visible, and how do they protect themselves when they are on the internet. And remember, there is no protection, even if it's copyrighted. If you put something on the internet and you can see it, it can be copyrighted and infringed. There's no doubt that if you've got a registration with the Copyright Office, then you've got great rights. And if you've got a great attorney, you can probably win the case. But I think you know what I'm sort of saying, that we're entering a really interesting period. And I think that the reflex action of lawsuits might not be the best remedy here. And especially for young artists, because I think it's very time consuming and sort of emotionally disruptive, when I think they should be focused on sort of creating, you know what I mean, and earning a living. I don't get infringed that much. I mean, quite honestly, and Scott will probably tell you, a big magazine is going to be very cautious about infringing any of my work. They have attorneys that check every submission because there's huge liability and they know it and they've been sued before. So as I said, most of photographers I know are not that concerned. It's really, and as I said, it doesn't matter to me if it's a sort of a fan pushing it on Instagram. It really helps me. And I've noticed my print sales have accelerated in the last 4 or 5 years. And I was dead against it, believe me. I was definitely dead against having any of my work online, but then I wasn't getting exposure, and everything's changed now. It is about being seen.
Understood. This is very helpful. Scott, do you have any other final words for artists out there who are trying to protect their copyright but still be visible?
It's a tough balance, because you have to be visible if you're going to make money, and somebody out there is going to copy your work. I mean, people just think that they're entitled to take whatever's on the internet. So you kind of have to take that risk if you're going to be a creative person in this, in this day and age. So the best thing to do is to protect yourself and make sure that you can enforce those rights when it comes down to it. And I think the combination of registering your copyrights with the Copyright Office and with whatever guild or collection society might be relevant to you, plus using services like Andy's to document your history of creation and licensing transactions, I think that's the best you can do. This is the world we live in, and there are people that are going to do bad things. And whether those bad things have unintended positive consequences for you in terms of promotion, or negative consequences in terms of lost revenue, it's all going to be circumstantial. But using the tools that are available to you, in as cost-effective way as possible is the best you can do. Because you got to be on social media, you got to be out there on the internet if you're gonna get your work sold. That's where everybody's doing it. So it's a balancing act for everyone.
Thank you, Scott. Thank you all for your attention. I'm going to turn it back to Athrea quickly, and we look forward to seeing you at our future Some Like It Digital conversations.
Thank you so much for attending, and thank you, Scott and Andy, for the presentation. Just to let you know, we will send across a survey. It'll be wonderful if you could fill that out. I've put it in the chat as well, and you can let us know what you'd like us to cover next. We have more events coming up. One is on copyright for artists post the Andy Warhol decision. We have immigration, legacy, and estate planning. But let us know what you would like to hear from us, or if you have any speaker suggestions. And we will be in touch soon. Thank you so much once again, and hope to see you in person in November for some of our film screenings and other in-person events that'll happen in the next couple of months. Thank you.
Thanks.
Thank you.